Dr. Anju Sinha Madam, Assistant Professor, Faculty of Law, Delhi University. I cordially welcome all the participants throughout India, that is principals, teachers, educators, students. I heartily welcome my beloved principal, Dr. C.M. Rao sir, who always encourages to organize such a program. Once again, I welcome you all in this second sessions of this 1 week lecture series. Thank you. Over to you, Yukta.
Good afternoon
Yukta.
to one and all present here. Sir, am I audible?
Yes, you are audible.
Good afternoon to one and all present
निकल
here.
जाओ.
I, Yukta Goge from BLLB second year, welcome you all on the second day of Indian Evidence Act lecture series on the topic Evidentiary Value of Dying Declaration, organized by ML&G Society, Manikchand Pahari Law College. Today, I have the privilege to introduce our resource person, Dr. Anju Sinha ma'am. Dr. Anju Sinha ma'am is Assistant Professor of Law at Law Center 1, Faculty of Law, University of Delhi. Ma'am holds LLB and LLM degree from Aligarh Muslim University. Ma'am has PhD in Law from Faculty of Law, University of Delhi, and her doctoral thesis deals with open prison, the working and utility as institutions of reformation and rehabilitation, an empirical study of Rajasthan Open Jail. Ma'am has taught across wide range of subjects since 2009 and presently teaching constitutional law, law of evidence, rent control, and slum clearance. Ma'am has authored various articles in journals of national and international repute and has presented papers of various conferences. With an experience of 12 years in teaching, her areas of interest are constitutional law, law of evidence, human rights, and prison reforms. Ma'am, we are so grateful that you're here with us today. Before we proceed, there are a few instructions for our attendees. One, there will be a question and answer session at the end of this program, and all the attendees are requested to post their questions in the Zoom chat box and YouTube live section comments. And also, we request them to make sure that their questions are relevant and near to the topic that we are discussing today. And secondly, we request all the attendees to make sure that their cameras are off and they're mute so that we can go along this program without any hindrance. Now, without any further delay, I would request Dr. Anju Sinha ma'am to enlighten us with her words. Over to you, ma'am.
Thank you, Yukta. A very good evening to all of you. First of all, I would like to thank the organizers of this event for giving me this wonderful opportunity. Indeed, it's my privilege to make a presentation before this August gathering regarding evidentiary value of dying declaration. I will be taking questions, comments, and suggestions towards the end of my presentation, as pointed out by Yukta. So, coming to the topic, I would like to mention from the very beginning, like whenever any offense has been committed, there are always two persons. One who knew what actually has happened, that is the accused, and accused who committed the offense, and another one is the victim with whom the offense has been committed. Now, in order to prove their position and make one's story to be true, they give a statement to the judge, but their story alone cannot rely on the veracity of the statement which they made to support their stories, as it may be prejudiced or untrue. So, generally, the role of witnesses, it becomes crucial to determine the truth, and always it is being decided on the basis of material and other evidence before the court. But the next question is how the court will decide a case where a victim is dead. Now, here comes the role or importance of dying declaration. The topic for today's presentation is evidentiary value of dying declaration. But before discussing evidentiary value of dying declaration, I would like to explain the very basic concept, that is, what is dying declaration? Now, dying declaration is a statement made by a person at the time of his death. So a statement made up by a person at the time of his death is known as dying declaration. Now, Indian law recognizes the fact that a dying man seldom lies, or truth sits upon the lips of a dying man. Section 32(1) of the Indian Evidence Act 1872 explored the concept of dying declaration. Section 32 of the Indian Evidence Act deals with the cases related to a person who is dead or cannot be found. So a dying declaration is called as latum mortem. The word latum mortem means the words said before death. A dying declaration is admissible in evidence even though it has not been made on oath and the person making it cannot be cross-examined. So in a way, dying declaration is an exception to the rule of hearsay evidence. Now, one of the cardinal principles of law of evidence suggests that fact must always be proved by direct evidence. Direct evidence means the fact which can be perceived by using our five senses. So in other words, only direct evidence of a fact is admissible, no matter how important particular evidence may be. Unless it comes within the class of admissibility, it is excluded. So in case of dying declaration, the direct oral evidence of a fact and the opportunity of examining the truth of such evidence by cross-examination is dispensed. It is dispensed with because the maker of the statement is dead. And no better evidence of the circumstances one can have other than the statement of the person so made. So as a general rule, when we talk about general rule, hearsay evidence is not admissible because hearsay evidence is not considered as a good evidence. But the rule against admission of hearsay, and at the same time, the rule against admission of hearsay is also a fundamental rule. So generally under evidence with few exceptions, certain exceptions are there in the Evidence Act, but the general rule is that hearsay evidence is not admissible because it is not considered as a best evidence. And also it is not delivered on oath. So the truthfulness and the accuracy of the person whose words are spoken by another witness cannot be tested by cross-examination. So the basic reasons why this hearsay evidence is excluded, the first reason is that it is not a best piece of evidence. Number two, it is not delivered on oath. As I mentioned, this hearsay evidence is not delivered on oath. Third is the accuracy or truth is diluted every time when it is being repeated, and also resulted possible inaccuracy through repetition is there. And another point due to which hearsay evidence is not considered as a good evidence or best evidence is that accuracy of the maker cannot be tested in cross-examination. And at the time of liability, the maker can easily escape by saying that this fact has not been witnessed by me directly. I have been told by someone. So these are the reasons why this hearsay evidence is not being admitted. It is not being considered as good evidence. But as I mentioned, that dying declaration as exception to the general rule. In spite of being hearsay evidence, it is a relevant evidence. It is substantive piece of evidence. So admissibility of a dying declaration as a relevant piece of evidence is guided by the principle of necessity and religious belief of older days. The necessity being that in case where victim is the only eyewitness to the crime, the exclusion of his statement might defeat the end of justice. Like if his testimony is not being considered as evidence, then the guilty person will not be punished because there is no other evidence on record to punish him. So only because if we exclude dying declaration, there is no other material to prove him guilty, The dying declaration cannot be excluded under the circumstances. So this is there is a necessity behind accepting dying declaration as a relevant piece of evidence. And as I told you, along with the principle of necessity, there is religious belief also behind this, behind acceptance of dying declaration as relevant evidence. And the religious belief is that a dying man seldom lies. So thus, when a person is dying, or when a statement is being made by a person when he is dying, when he knows that he is going to meet his maker, he would not like to meet his maker with a false on his lips. So this is the main religious belief over which this entire doctrine is based, that dying man seldom lies. So thus, when a statement is being made by a person as to the cause of his death, or as to any circumstances of transaction which resulted in his death, in cases in which cause of that person's death comes into question, such statements are relevant whether the person who made the statement was at the time of making that statement was under expectation of death or not. And this is a difference between Indian law and English law on this point of time. If we compare dying declaration under English law with dying declaration, the provisions dealing with dying declaration under Indian law, there are basic two differences between the two category of laws. Under English law, the person, when he is making dying declaration, he must be under expectation of death. He must be sure that expectation of death, it should be he should be very sure about that when I'm making this statement, after that I'm going to die 100%. So that expectation of death concept is very important under English law. This is the first point. The second point is, under English law, the dying declaration is relevant only in cases of homicide. That is, it is relevant only under criminal cases. But if we analyze the provisions of dying declaration under Indian law, under section 32(1) of Indian Evidence Act, then the difference between English law and Indian law is very clear, because under Indian law, it is not necessary that when a person is making dying declaration, he is under expectation of death. He may die later on, because the statement will become dying declaration only when a person dies. But it is not necessary that at the time when he is making the statement, he is under expectation of death. So this is the first difference between English law and Indian law on this point. The second difference is that under Indian law, dying declaration is relevant in both cases, in civil cases as well as in criminal cases. It is relevant in case of homicide as well as in case of suicide. So this is a very broad difference between the two laws, between the English law and Indian law. Now, when we talk about dying declaration, the next question which comes in our mind is, who may record dying declaration? Who may record dying declaration? The answer is that any person can record dying declaration. Obviously, if a dying declaration is recorded by a judicial magistrate under section 164 of CRPC, that stands on much higher evidentiary value. But that does not mean that the judicial magistrate is the only authorized person to record dying declaration. Dying declaration can be recorded by any person. It can be recorded by a doctor, it can be recorded by a police officer, it can be recorded by a family member, it can be recorded by a friend. So there is no such restriction that who is legally authorized to record dying declaration. Whosoever is near the person, whosoever is near the victim at the time of incident, that person is entitled to record the dying declaration. But as I told you, if we compare the evidentiary value of dying declaration, then the dying declaration recorded by a judicial magistrate, it stands on much higher footing. Then after that, the next point is, what is the form of dying declaration, or how dying declaration is to be made? There is no specific form provided in the Evidence Act. Dying declaration can be in written form, or dying declaration can be made verbally, or even dying declaration can be made by way of gestures. So gestures also, if a person is able to communicate clearly by using his gesture, even that can be a criteria or that can be a basis to convict a person if the court is convinced. And if other parameters and guidelines which have been given in subsequent cases, which I'll discuss with you, there are certain guidelines which have been given by judiciary. So if those criteria and if those guidelines are fulfilled, then even a dying declaration made by way of gesture is admissible and conviction can be made only on that basis. And the very best example of dying declaration in by way of gesture is a very famous case. It is Queen Empress versus Abdullah. Now, Queen Empress versus Abdullah was a case where the victim was a lady, her name was Dulari, and she was attacked by the accused. And her throat was cut and her throat was so badly injured that she was not able to speak. She was unable to speak, but she was conscious and she was able to make gesture and signs. So when she was asked this question by the doctor, then by the police officer, and ultimately before the magistrate, when the question was asked that who had wounded her. So as I told you, due to her injured condition, her throat was badly injured. So she was unable to speak. But by using gesture and by using the sign language, like the magistrate, he mentioned several names one by one. And he was, after mentioning name, he was asking that if they had wounded her. So Dulari, she moved her hand forward and backward and yes sign in negative and affirmative sign. And by using this negative and affirmative sign, she was able to identify the accused. She was able to tell that this was the person who attacked on her. And subsequently, when the magistrate asked that how Abdullah was a accused person, how Abdullah had wounded her, for that, Dulari, she waved her hand and made a sign of like sign in affirmative, like yes, I was wounded by Abdullah, and how she was wounded, by knife or sword or by razor. So she made negative sign in other two, and she made a positive and affirmative sign when the word razor was mentioned by the magistrate. So by using sign language, she was able to communicate to the magistrate that she was attacked by Abdullah and she has been wounded with razor. And after that, after some time, she died. So her statement was considered as a dying declaration, and on the basis of her dying declaration, Abdullah was convicted. So this is when I mentioned that form of dying declaration has not been mentioned. It can be in written form, it can be verbal, or it can be by way of gesture or by using sign language. So dying declaration, and when we talk about dying declaration, there are certain condition precedent, because dying declaration, it is based upon the principle of necessity and the principle of religious belief that when a person is dying, he is speaking truth. He is not implicating the innocent person. He is not making false statement. But there are certain conditions precedent for admissibility of dying declaration, which are to be considered by the court before considering that statement as dying declaration. The first important point is that the person who made that statement, he should die. As I told you, that the statement will become dying declaration only when the person dies. If the person does not die, if a person survives after making that statement, the statement will not be treated as dying declaration. But that does not mean that the statement will not be having any evidentiary value, and that does not mean that evidentiary value of the statement will come down to zero. The statement will still be relevant, but it can be used only for the purpose of corroboration or contradiction of previous or subsequent statements. But certainly in that situation, the statement will not be dying declaration. Now, another important point with respect to dying declaration is that dying declaration must be complete. What is the meaning of dying declaration must be complete? It means that accusation part of dying declaration must be complete. if the person dies before completing the accusation part, then that dying declaration will not be relevant. Say, for example, if the injured person is saying so many other things, but after saying other things, the moment he is coming to the name of the accused, before taking name of that accused person, he dies. So in that situation, that statement, because it is incomplete, accusation part is not complete. So that incomplete dying declaration will not be relevant. And dying declaration, when we are referring to dying declaration, it must be voluntarily made a statement. It must not be made under influence of anybody. It must not be a result of tutoring to that victim. So this is a very important aspect of dying declaration, which is to be analyzed by the court. The dying declaration must be voluntarily made and it must be uninfluenced statement. A statement must be regarding the cause of his death. Because if you read section 32 subclause 1, it says that dying declaration is a statement which is related to the cause of his death. So his is this particular word is very important here. If a person is making a statement regarding the cause of death of any other person, but he is not referring to the cause of his death, and before he is coming to the cause of his death, before describing that he dies, then that statement will not be relevant as dying declaration, because in that situation, what that statement is all about, the statement is not referring to the cause of his death. What it is referring to, it is referring to the cause of death of another person. And if the statement is referring to the cause of death of another person, it is not relevant as dying declaration. So for a statement to become relevant as dying declaration, it must be regarding the cause of his death. It must be regarding the cause of death of that particular person who is making that statement. Then the cause of death must be explained by that person who is making the statement, or the circumstances which resulted in his death must be explained. And the person who is making that dying declaration, he must be conscious, he must be coherent, he must be in fit mental condition to make the statement. Generally, the certificate of the doctor is considered regarding that, and certificate is being given by the doctor that the person who is making that statement is in fit mental condition to make the statement. He is in sound state of mind, because dying declaration can be the sole criteria for convicting a person. So it is very important to know that at the time when the person is making the statement, whether he was in fit mental condition, whether he was in sound state of mind and he's making, because that statement, whatever he is saying, if he dies after that, that statement, it cannot be, it is not open to cross-examine, because cross-examination is a very important tool for the purpose of checking the credibility of the witness. But in this case, the person who made the statement is already dead. So this statement is not open to cross-examination, and also this statement is not made on oath. So that certificate of doctor is very important for the purpose of proving that the person at the time when he was making a statement, he was conscious, he was coherent, he was in fit mental condition to make the statement. And whenever we are referring to this statement regarding death, there must be proximity of time of a statement and death. It's very important that proximity of time of a statement and death. It is not required that when a statement is being made by a person, he must die immediately after that. The person may die after 2 weeks, after 2 months, after 3 months, it depends. But there must be a nexus, there must be a connection, and there must be proximity of time of a statement and death. There must be a nexus between his statement and his death. He must die because of that reason which he has given in his statement. If his death is because of any other reason, if he has stated something else in his statement and he dies because of some other reason, say for example, if a person is injured and admitted in the hospital, he's being treated, he's cured, and when he was admitted in the hospital, he made a statement and he said that I was attacked by such and such person, and that person attacked, this grievous injury is because of that person. So this is his statement. But if this person does not die, and if this person is being treated in the hospital, and if he has been discharged from the hospital, and after 6 months of his discharge, he dies because of some other reason, then his earlier statement, which he made at the time when he was admitted in the hospital, cannot be considered as his dying declaration, because there is no nexus between that statement and his ultimate death. So when a person is making a statement under section 32(1) regarding cause of his death, it must be related to, there must be a direct nexus between that statement and cause of his death, number one. And number two, there must be proximity between the time of a statement and death. So this is the first ingredient of section 32(1), that the statement must be related to cause of death. Now, section 32(1) has got another ingredient also, which says that circumstances of transaction which resulted into death. So dying declaration is basically two kinds of a statement are covered under this particular part of Evidence Act. The first one is that the statement which is related to cause of death, cause of his death, and second one is circumstances of transaction which resulted into death. Now, circumstances of transaction which resulted into death it's a very broad concept, and so many things which does not come under the first ingredient, they will come under this second ingredient. A very good example of this particular ingredient is a case which I am going to refer, that is Pakala Narayan Swamy versus Emperor. Now, Pakala Narayan Swamy versus Emperor was a case in which the victim, when he was going, actually victim has given certain amount, certain finances were given, like accused borrowed certain finances from the victim. So when the victim, he demanded back his money, then accused said that you come to my place and I will pay your money. So this was the communication between the victim and the accused, and actually this communication was through letters. The letter was written by the accused to the victim that you come to Behrampur and I will give you, I'll pay back your money, whatever I am supposed to return to you. So this person, this victim, he showed that letter to his wife and he said that I'm going to Behrampur for the purpose of collecting my money. So after saying this, he left for Behrampur. He reached there, and next morning his body was found cut in pieces, and it was packed in a trunk, and it was found in a train, railway compartment. So this trunk in which his body was found, it was purchased by the accused, it was proved. And during when the case was filed against that person, then other evidence was produced before the court, but the prosecution wanted to use this letter as his dying declaration. An objection was raised on the defense side that no, it is not related to cause of his death. So because this letter is not related to cause of his death, it cannot be treated as his dying declaration. But this contention was not accepted by the court, and it was held by the court in Pakala Narayan Swamy versus Emperor that the letter was related to the circumstances of transaction which ultimately resulted into his death. So this letter is relevant as dying declaration under second ingredient of section 32(1). Circumstances of transaction which resulted into death, because that letter was mentioning, it was mentioned in the letter that you come to Behrampur and I will pay you the money. After receiving that letter, this person, the victim, he left, the deceased, he left for Behrampur. So this letter, it deals with the circumstances of transaction which ultimately resulted into his death. So that is why in Pakala Narayan Swamy, it was held by the court that it is the letter is very important as dying declaration. So these two ingredients, both the ingredients, they are relevant when we talk about 32 subclause 1. that either the statement can be related to cause of his death, or it can be related to circumstances of transaction which is resulting into his death. In both cases, the statement will be treated as dying declaration if the person dies after making the statement. Now, when we are talking about dying declaration, there can be another situation that there can be multiple dying declarations. There can be consecutive dying declarations. So if there are consecutive dying declarations, then how the value or how the evidentiary value is to be decided by the court. Now, one thing I would like to mention here, that there can be a situation, there can be a genuine situation where multiple dying declarations are being made. Say, for example, if a person is injured, the first dying declaration he may make to his family member who is attending that person. Then if that person is being taken to the hospital, or if police is being informed, then second statement can be made to the police. Then if he has been taken to the hospital, the third statement he can make before the doctor. Or the situation can be different, like he has been taken directly to the hospital, so second dying declaration he is making to the doctor. And then police is being called, then third dying declaration he is making before the police. And if time is there, because it depends upon the condition of that person, if he is able to survive, if time is there, then judicial magistrate will be called. So if judicial magistrate is being called, then a statement will be made, it will be recorded by the judicial magistrate. So this is a situation where 4 dying declarations have been made, multiple consecutive dying declarations have been made. What is the status of these kind of dying declarations? Look, if all the dying declarations, if they are consistent throughout, if there is consistency between the dying declarations, then they are relevant. And then there is no need for corroboration, and conviction can be made on that basis. But if they are inconsistent with each other, like if in first dying declaration, the victim is saying something else, in second dying declaration, he is taking name of another person. So if that kind of inconsistency is there, or if dying declaration is not matching with the facts and circumstances of the case, so if any kind of inconsistency is there, then dying declaration, it is not relevant to the extent, like it cannot be the sole criteria to convict a person. Then in that situation, corroboration is necessary. But otherwise, if there are multiple dying declarations, consecutive dying declarations, if they are consistent throughout, then there is no need for corroboration. And this point I will cover under that evidentiary value of dying declaration, which I am going to discuss with you. So with these basic concepts which I discussed with you, I believe that the very concept of dying declaration under section 32(1) is clear to all of you. Now coming to the main topic, that evidentiary value of dying declaration. What is evidentiary value? Now, evidentiary value of dying declaration, it depends upon case to case, and in initial cases, the Supreme Court was of the opinion that dying declaration alone cannot be the criteria to convict a person. The Supreme Court was of the opinion that there should be some other material to corroborate that statement. So the main case on this point, which I would like to refer, is Ramnath versus State of Madhya Pradesh. Ramnath Madhu Prasad versus State of Madhya Pradesh. Now, in that case, it was held by the Supreme Court that it is a settled law that it is not safe to convict an accused person merely on the evidence of a dying declaration without further corroboration. So the entire emphasis of the court was on corroboration, that it is not safe to convict a person only on the basis of dying declaration unless or until there is some corroboration, unless or until the dying declaration is supported by some other evidence. Why? Because dying declaration is a statement which is not made on oath, and dying declaration is a statement which is not subject to the cross-examination. And also the maker, it might happen that the person who is making the statement at that particular point of time, he might not be mentally or physically in the state of compassion, and he might be drawing upon his imagination while he was making that statement. Thus, in Ramnath Madhav Prasad versus the state of Madhya Pradesh, it was very clearly held by the Supreme Court as a safeguard that corroboration is essential. Unless or until corroboration is there, dying declaration cannot be acted upon. Like, dying declaration cannot be the sole criteria for the purpose of convicting a person. But later on, the opinion of the Supreme Court has changed, and Ramnath Madhav Prasad case has been overruled by the court in Khushal Rao versus State of Bombay. In Khushal Rao versus State of Bombay, it was held by the court that dying declaration can be a sole criteria. Obviously, scrutiny is required because dying declaration is a statement which is not made on oath, and also this is a statement which is not open to cross-examination. So strict scrutiny is required. That religious belief is also there, that when a person is dying, he is making a true statement of fact. He's not, no person would like to make his, to meet his maker with a false on his lips. All these things are there, but still there can be a situation that even in spite of all these beliefs, when a person is dying, he is being tutored by someone, or he is making false statement due to certain kind of deeply, very deep enmity which is there in his heart. There can be numerous instances, or there can be a number of reasons for that. So the court says that strict scrutiny is required. Without scrutiny and without following the principle and guidelines which have been given by the court, dying declaration cannot be the sole criteria. But yes, if after scrutiny, and if after scrutiny, if the court believes that this particular statement meets all the parameters which have been given by the court, then there is no need for corroboration. Then dying declaration can be the sole criteria for convicting a person. So in Khushal Rao versus State of Bombay, it was held by the court that it is not absolute rule of law that dying declaration cannot be the sole basis for conviction unless corroborated. There is no such absolute rule of law. So a true and voluntarily made dying declaration needs no corroboration. So the court has to be very careful that whether it is a true and voluntarily declaration, or this statement is a result of certain tutoring. So that kind of scrutiny is to be done. But this was the first point which was laid down by the court in this Khushal Rao's case. Then also in this case, it was held by the court that a dying declaration is not a weaker kind of evidence. It is as equal to any other piece of evidence. It is not a weaker kind of evidence than any other piece of evidence. But at the same time, each case must be determined on the basis of its own facts and circumstances. Facts and circumstances in which the dying declaration was made. So that is very important, that the facts and circumstances in which that dying declaration was made, it is to be considered, and each case is to be determined on that basis. But yes, dying declaration stands on the same footing as any other piece of evidence. And it has to be judged in the light of surrounding circumstances and with reference to the principles governing the weight of the evidence. At the same time, a dying declaration which is being recorded by a competent magistrate in a proper manner. If you remember, I told you that dying declaration can be recorded by any person. There is no such requirement of law that dying declaration can be recorded only by a judicial magistrate or only by the doctor. No, dying declaration can be recorded by any person, be it can be a family member, it can be a friend, it can be a doctor, it can be a judicial magistrate. But you have to keep this point in your mind, that a dying declaration which is being recorded by a competent magistrate in a proper manner, although no form of recording of dying declaration is being provided, but preferably it should be in the form of questions and answers if possible, if practicable, in the words of maker of the declaration. So if a dying declaration has been recorded by a competent magistrate in a proper manner, that is in the form of question and answer, And it is, in the words of the maker of the declaration, it stands on a much higher footing than a dying declaration which depend upon oral testimony, because oral testimony may suffer from all the infirmities of human memory and human character. So this is the reason that whenever a dying declaration is being recorded by a competent magistrate in a proper manner, in a question and answer format, in the words of the declarant, as far as it is possible, it always stands on higher footing than in comparison to any other dying declaration. But it is wrong to say that dying declaration can be recorded only by the judicial magistrate, because as I mentioned earlier, it can be recorded by any person. But only the evidentiary value varies according to that the person who has recorded it. Like if it has been recorded by judicial magistrate, higher evidentiary value is being given. But at the same time, when we are referring to evidentiary value and when we are referring to this dying declaration that it can be a sole criteria for the purpose of convicting a person, one more thing is to be, or one more test is to be, one more very important parameter is to be considered by the court. And that is, the court has to keep in mind the circumstances. What kind of circumstances? The circumstances like the opportunity of dying man for observation. For example, whether there was sufficient light if the crime was committed in the night, whether the capacity of the man to remember the facts stated had not been impaired at the time when he was making this statement by the circumstances beyond his control, or that the statement was consistent throughout if he had several opportunities of making a dying declaration apart from the official record of it. And also, the statement has been made at the earliest opportunity and it was not a result of tutoring by interested party. So this is a very, very important point. And these are the very important parameters which are to be considered by the court at the time of scrutiny of the dying declaration. Because if a person is being convicted only on the basis of dying declaration, that can be done. It has been held in Kushal Rao that no corroboration is required. But no corroboration is required at the same time. A strict scrutiny of dying declaration is required. So these parameters, like whether there was opportunity of dying man for observation, whether there was sufficient light if the crime is being committed in night, because if it was dark, how he was able to recognize, how he was able to acknowledge that the crime is being committed by such and such person. So these very, very minute point, they play a very important role for the purpose of deciding the evidentiary value of dying declaration, whether the person was capable to remember the facts, whether his capacity to remember the facts had not been impaired at the time when he was making this statement, and whether if he is making dying declaration again and again, apart from official record, there is no inconsistency in his statement. All these statements, they are consistent throughout. And it was not a result of tutoring. As the very first point I mentioned, that it is a voluntarily made statement. So this is very important, that it is not a result of tutoring by interested party. And that is why it is to be made by at the earliest opportunity, so that there is no time to tutor that person. There is no time to tell that person, or there's no time to put words in the mouth of that person who is going to die. So these are the parameters which have been laid down by the court in Kushal Rao's case. And if these parameters are fulfilled, then conviction can be made only on the basis of a statement made by the deceased person, by the victim, and there is no need to corroborate. There is no need of corroboration. The court will not look for any other material or any other evidence. But yes, if inconsistency is there, if doubt is there, if the court feels that it is not safe to convict a person on that basis alone, then the court will definitely look for corroboration. So that was Kushal Rao's judgment. Then after that, again in Harbans Singh versus State of Punjab, the Honorable Supreme Court again held the very same point. Again, it was held by the court that it is neither a rule of law or rule of prudence that a dying declaration requires corroboration by other evidence. So conviction can be made only on the basis of dying declaration, and there is no need for corroboration. Then again in K.R. Reddy versus public prosecutor, K.R. Reddy versus public prosecutor was a case in which the evidentiary value of dying declaration was observed by the court. And the Supreme Court, it was held by the Supreme Court that dying declaration is undoubtedly admissible under Section 32, and no matter it is not being a statement on oath, and its truth cannot be tested by cross-examination. It is admissible under Section 32, irrespective of the fact that it is hearsay evidence, irrespective of the fact that it is a statement not administered on oath, cannot be tested on cross-examination. It is very much admissible under Section 32. Then in that case, it was also held by the court that court has to apply scrutiny, and very closely the court has to analyze that statement before acting upon it. The parameters we have discussed given in Kushal Rao's case. So the court has to apply those parameters. The strict scrutiny of that statement is required. Only after that, if the court is satisfied, then the court is free to convict a person on the basis of that statement alone. Now, as I told you, great sanctity is attached to the words of a dying person. Great sanctity is attached to the words of a dying person. Why? Because a person on the verge of his death is not likely to tell lies. A person on verge of his death is not likely to connect a case as to implicate an innocent person. But in spite of this, the court has to be very vigilant, and the court has to be on guard against the statement of deceased being a result of either tutoring, prompting, or a product of his imagination. So this is a very important point which the court has to analyze very carefully, that whatever statement that person has made, whether that statement was made by him voluntarily, or it was a result of tutoring, prompting, or it is only a product of his imagination, it never happened. So these are the things which are to be considered by the court, and this is a very important point which has been referred by the court in K.R. Reddy versus public prosecutor. In the very same case, it was held by the court that court must also be satisfied that the deceased was in fit state of mind. He was in fit state of mind to make the statement, and he had clear opportunity to observe and identify his assailant. And he was making this statement without any influence or without any kind of tutoring. And once the court is satisfied, the dying declaration is true and voluntarily made. Once the court is satisfied that this statement is not a result of any tutoring, prompting, or it is not a product of his imagination. And if the court is again also satisfied that the person who at the time when he made this statement, he was in fit mental condition, he was in fit mental state to make this statement, then it is sufficient for the court can convict a person only on the basis of that kind of statement without any further corroboration. It's a very important cases in which it has been held by the court that a person can be convicted in case of dying declaration. There is no need for corroboration. Another case we can refer when we are referring these cases, we can also refer the state of UP versus Ram Sagar Yadav case. In the state of UP versus Ram Sagar Yadav, again, the similar kind of observation was made by the Supreme Court. So we have series of cases in which it has been held by the court that a dying declaration can be the sole criteria for the purpose of convicting a person, and there is no need for corroboration. So in the state of UP versus Ram Sagar, again, it was held by the court that the main effort, the primary effort of the court is to find out that whether dying declaration is true. And if it is true, then there is no question of corroboration. It is only if circumstances surrounding the dying declaration is not clear, or if the court is not convinced, if the circumstances, they are not convincing the court, then in that situation, the court may, for its assurance, look for corroboration to the dying declaration, and then after looking for corroboration, and then on the basis of that corroborative evidence, the court can reach to the conclusion. But again and again, I'm repeating the same thing. If the court is convinced, if the court feels that the statement was voluntarily made a statement, if the court feels that the statement was not a result of any tutoring, prompting, or it was not a result of his imagination, the court is free to convict a person only on the basis of dying declaration, and then there is no need for the court to look for any other corroborative evidence. And the last example I would like to give, the very recent case decided by the Supreme Court in January 2020, that is Purushottam Chopra versus State. In Purushottam Chopra versus State, it was held by the Supreme Court that even if the victim, it was a case of 100% burn victim. So it was held by the Supreme Court that the statement of even 100% burn victim will be considered as dying declaration if that person dies after making that statement, and if at the time of making the statement, that person is in fit mental state. So the person is in fit mental state to make the statement. This is a most important point, as I mentioned earlier. And whether a person is in fit mental state or not, that can be decided on the basis of certificate given by the doctor. But if in a particular case, if that kind of certificate has not been given by the doctor, that will not be fatal to the case. It can be, and even if there is a conflict, say for example, if doctor says that the victim was conscious, he has not used the word in fit mental condition, but there is an eyewitness, and eyewitness, he was present at that point of time when the dying declaration was being recorded, and he says that the person was in fit mental condition at the time when he was making the statement, then that eyewitness's statement will prevail over that, over the statement given by the doctor. So that is a requirement is there that whether he was in fit mental condition, a certificate is to be given. But if certificate has not been given, even then, if there is an eyewitness, if he says that when this person, when he was making the statement, he was in fit mental condition, then that will be considered sufficient by the court. And if the court is otherwise satisfied, if that statement fulfills all other criteria, all other parameters, then it will be accepted as a relevant dying declaration, as a substantive piece of evidence. It will be accepted, and then there is no need for any corroborative other material. There is no need for corroboration. The court can convict a person only on that basis. So this was in brief. I tried to give an idea regarding that evidentiary value of dying declaration, what is dying declaration, and the most important point I mentioned when I started this topic, that a statement becomes dying declaration only when a person dies. If that person does not die, if that person survives after making that statement, then the statement will not be considered as dying declaration, although it can be used in evidence. It can be used for the purpose of corroboration or for the purpose of contradiction, but certainly it cannot be used as dying declaration. So I hope that the point which I wanted to make clear to all of you, and regarding dying declaration, now if you want to ask any, now the floor is open for your questions.
Thank you, ma'am. Your words have truly enlightened us. I would request Professor Kolpe sir to conduct the question and answers part.
Thank you, Yukta. Please, those who have the question, please put their questions in a chat box. I hope.
Madam. Sir.
Madam, our principal sir is talking.
Okay.
So you referred to latest case of January 2020.
Yes, sir.
Where you said that 100% burns. 100% burns case where the person makes the statement and it was considered to be a valid one, as you said.
Yes, sir.
When 100% burns are there, how she is going to be prove the signature or any other things?
Sir, that is the main thing, because when I said that the very important point I mentioned earlier in my lecture, if you remember, I said that the person must be in fit mental condition to make this statement. And that lady Sorry, it was not a lady, it was a male person.
Male
And
person.
yes, and at the time when he made that statement, he was in fit mental condition in spite of being 100% burned. He was in fit mental condition to make this statement. So that is a very important aspect which is to be considered at the time when the relevancy of that statement is to be considered by the court.
And another thing you said, when an eyewitness is there when the statement is made.
Yes.
Forget about that case, you also made another statement in which if a eyewitness is going to say that the particular person is conscious of what is going on. So I am a doctor, I know the condition, but the person who is standing besides me, he may not be aware of the condition of the person. You got the point?
Yes, yes, sir.
So the deceased is in a condition which was known to the doctor, but the eyewitness who is hearing the statement may not be in a position to have the consciousness of the particular person.
Sir, as I mentioned, everything depends upon facts and circumstances of cases. This statement which I made, it is based upon Parambakka's case, and in that case, the statement was given by the doctor that the deceased was she was conscious. So the dispute was that word conscious is not referring to fit mental condition. So it cannot be accepted as it is at the time when she was making a statement, she was in fit mental condition. So in that case, it was held by the court that if eyewitness is saying that she was in fit mental condition, and if there is a conflict between the two statements, then the statement of eyewitness will prevail over that statement in which the doctor has said that she was conscious.
Okay.
So it was on the basis of that particular case.
Okay, thank you.
Obviously, otherwise the doctor is the better person to judge. Yes, sir.
Thank you, madam. There is a question from if the declarant made a statement regarding death of another person, including his own, as he himself dies, then such a dying declaration is relevant as to his own death as well as another.
That statement will be relevant as regarding his own death. It will be considered as his dying declaration, but it will not be relevant regarding the death of another person. Because you are saying, so far as I understand, it's a very important, it's a very good question, that a person is making a statement regarding his own death and death of another person. So if he is able to complete his statement regarding his own death and death of another person, then that part of his statement which he is referring to the cause of his death, that will be considered as his dying declaration regarding cause of his death, but his statement cannot be considered as dying declaration regarding cause of another person's death. Is it clear?
Thank you, madam.
And there was a case on this point where there were two sisters, and the sister, she made a statement regarding the death of her other sister. Like, my elder sister died, she was attacked like this, and in detail she made the entire description, but before she could come to the cause of her death, she died. So in that situation, the statement was not considered as her dying declaration, because in that situation she was not referring to the cause of her death. Her entire statement was related to the cause of her sister's death. Okay.
Thank you, madam. There is a question from the Onkar Vaidya. If the dying declaration is in the language which witness does not understand, in such a case, can video recording be of evidentiary value or not?
Normally, the dying declaration should be recorded in the language of the person. But if in some case it is not being recorded in the, like if a person is speaking Telugu, and if it is being recorded by a judicial magistrate, it is being translated in English and it is being signed by a witness who is standing there, that will be considered as a relevant dying declaration. But generally, it is being preferred that it should be recorded in the language of that person.
There is a question from the advocate Rajni Bhaskar from Khamgaon, Buldana. The fitness is depend on the age and immunity of the person. The percentage of burns is not material.
Yes, you are right. The percentage of burn is not material. The fitness, fitness depends upon his mental state. No matter he's 20 years old or he's 60 years old. If he is mentally fit to understand the circumstances, and if he is mentally fit to answer the questions which are being asked to him, then he is in fit mental condition, irrespective of, there can be a case of even 100% burn, and that person may be in fit mental condition to answer that the questions which are being asked to him.
No, madam, no, 1 minute. In the case of 100%
not audible, sir.
So in case of 100% burns, the opposition may have a chance, defense may have a chance to attack the particular thing that it is not reliable. It
Yes.
may create benefit of doubt in the mind of the judge.
That is always open.
That is always
That
open.
is always open. I'm not
Yes.
on that aspect.
Okay.
But as a dying declaration, even if a person is, if 100% burn, he or she is having, if he or she is in fit mental condition, his or her statement will be considered as dying declaration. It is open to challenge. The defense can always raise a question, but then the court can look for corroboration. Under these circumstances, the corroboration might be required. I hope I'm able to clear this point. I hope this point is clear to you. You are not audible, sir.
Next, madam. Okay.
Yes.
I am not asking the question for me. I am asking for the clarification of students.
Yeah, I know, sir, and I appreciate that. It's a very good question, because many times the doubt will be there that if 100%
they don't ask
doubt,
the questions. To clarify the students only, I am asking certain questions.
Yes, sir, I understand. And it's my pleasure to answer your question, sir. Yes, sir.
There is a question from Gautami Zochi. If there are multiple dying declarations, what is value of statement recorded by other person than magistrate?
Yes, again, it's a very good question, because in case of multiple dying declaration, many times confusion is there that what is the evidentiary value of these multiple dying declaration. Now, in case of multiple dying declarations, I told you that if all the dying declarations, if they are consistent throughout, then irrespective of the fact with who has recorded that statement, no matter they have been recorded by the magistrate, or they have been recorded by the doctor, or they have been recorded by a family friend. If all the dying declarations, they are consistent throughout, they are relevant, and they can be a criteria to convict a person even without corroboration. Because there can be a situation that in spite of making multiple dying declaration, there was no time to call the magistrate. So if there was no time to call the magistrate, and the statement is being made before the police officer, before the doctor, or before the family friend, these multiple dying declarations, if they are consistent throughout, they are relevant and they will be considered by the court.
Thank you, madam. Yes. There is another question from Swapnil Chaudhary, Mumbai. If dying declaration recorded by family members, how trusted, how it reliable?
It is trusted because many times it may happen that no other person is present there to record the dying declaration except family members. And before that person, they have taken that person to the hospital. If that person dies, then that is the only statement made by that person before his death. So that statement cannot be discarded only on the basis that because it is being made to the family members and they are the persons who may be interested party. So that statement should not be considered. No, that kind of thing is not there, because even family members will be the first person to present that statement as it is before the court, because they want that guilty person should be punished. They will not want this, that innocent person, they will not want to implicate the innocent person. But under these kind of situations, certainly the court will look for corroboration. Under these kind of circumstances, if doubt is being created regarding the authenticity of a statement, or if a kind of doubt is there that because being an interested party, they are manipulating the facts, then certainly the court will look for corroboration. But otherwise, if the court feels that all the parameters are satisfied given in Kushal Rao's case, then there's no need for corroboration. Even a statement made to the family member can be a sole criteria to convict a person. It depends, again, I'm saying, it depends upon facts and circumstances of each case.
Thank you, madam. There is another question from Sheila Rajendra Patil. In case of accidental death, how the state of mind of dying person will be decided?
In case of accidental death,
how the state
of when the person is being either, if there is a time, the person will be taken to the hospital, and if that person is being taken to the hospital, then doctor is there to decide. But if there is not enough time to take that person to the hospital, then the person who is recording that statement, that person is the best person to judge that whether that person is in fit mental condition. Because if a person is asking a question to that person, and if that disease, the victim, he is able to give a rational answer, that means that person is in fit mental condition. So on that basis, that person will decide, and then he will put his signature on that, that in my opinion, that person, when at the time when he was making the statement, he was in fit mental condition to make the statement. So again, it's upon the court to decide that how much weightage is to be given to that kind of a statement. But yes, that kind of procedure is there, and we have various cases where the statement is being recorded by a person who was just passing nearby, and then it has been reported to the police, and by the time the person is being taken to the hospital, he succumbed to the injuries. So in that situation, that is the only statement which he made to that person. And I mentioned earlier, when I started, I mentioned that although it's a hearsay evidence, but it is accepted as exception to the hearsay rule, because if we exclude this statement, we don't have any other statement, and the accused will be acquitted because of lack of evidence. So this is the main reason why, out of necessity, this kind of statements, in spite of being hearsay evidence, although these kind of statements are not a statement made on oath, these kind of statements, they are not open to cross-examination, but they are being considered as a substantive piece of evidence. I hope your query is covered. Your query is covered in under this.
There is a question from the Sandeep from how the Paklanarayan Swami versus Emperor fits in a definition of dying declaration.
Pardon, sir? How the Paklanarayan Swami?
How the Paklanarayan Swami's case fits in definition of dying declarations?
It comes under second ingredient of dying declaration. If you remember, I told you that section 32(1), there are two ingredients. The first one is the statement made regarding the cause of death. Second one was regarding the circumstances of transaction which resulted into his death. So Paklanarayan Swami case will not fit under the first ingredient, because this was not a statement made regarding the cause of his death. But certainly it will fit under the second ingredient, because it was related to the circumstances of transaction which ultimately resulted into his death. It was because of this particular letter which he received, he went to Behrampur. It was written in that letter that you come to Behrampur, I will pay back your money. So he went there because of that letter, on the basis of that letter, and he was killed there ultimately. So this letter will come under second ingredient of dying declaration. It will come under second ingredient of section 32(1). That is circumstances of transaction which resulted into death.
There is a question from the Chirok. Name, please explain the record. When you say record the statement, does it mean only video recording?
No, record, when I say record, it means by using any means. It can be just noting down, because I'm not referring to video recording. When I say that the dying declaration may be recorded by any person, it may be like if a person is making verbal statement, another person is putting it, it's writing it down, or dying declaration may be made in a written form by that person. So by record, when I say I'm not this video recording, no, I'm not referring to that concept.
Thank you, madam. There is a question from the Trupti Kayande. After the making statement, the person goes into the coma state for long period, then his statement can be a dying declaration somewhere, because no one can know when the person is recovered.
In that situation, we don't have any such case, at least not in my knowledge, where a person after making the statement has gone into coma and his statement has been considered as dying declaration. Because that statement, when I'm saying that his statement cannot be considered as dying declaration, it means that that statement can still be considered for the purpose of contradiction or for the purpose of corroboration. But if that person is not dead medically, then to that extent, I don't know any judicial pronouncement in which it has been held, because as per my knowledge, unless or until the person is dead, the statement cannot be used as dying declaration. But this is a very good point, and it can be challenged in any case where it can be held by the Supreme Court that if a person is in coma, then in that situation also that statement should be given some more weightage. If it is not being considered as dying declaration, then at least it should be given some more evidentiary value in addition to for its use as for the purpose of contradiction and corroboration.
Thank you, madam. Another question is there. Whether what if there not enough time for the person to write down the dying declaration of the person? What if he manages to only listen to the dying person?
Yes, again, it's a very good question. It is not always necessary to write the dying declaration. If a person is not writing that dying declaration, he can appear before the court as a witness, and then as it is, he can repeat that statement. Like if that person is not literate, if a statement is being made to a person who doesn't know how to write, he is illiterate, then he'll not be able to write that statement. But many times it happens that if he is narrating that statement to the police or to some or before the judicial magistrate, then the statement is being noted down, is being recorded down by the authorities, and then his thumb impression is being taken on that. So both ways, both the options are open. Either his statement can be recorded by other person, and if he is illiterate, his thumb impression can be taken, or straight away he can go to the court as a witness and he can make a statement before the court.
Madam, there is another question from the Pallavi Kore. Is there a signature necessary after dying declaration?
Yes, signature or thumb impression. One of the things is necessary for the purpose of proving that if it is in written form. If it is in written form, then it is necessary. Yes.
Madam, there is a one suggestion is there that just one question was put to us that that person goes in coma, then it is not possible he will recover it. That there is a case of the Arna Shanbag. One participant saying that Mr. Sheikh from the Saudi Arabia is from the case of Bombay nurse. What is the case? She was in coma for a long time. Arna Shanbag case.
Okay, sir. So in that case, whether
regarding that, suppose the
no, sir, but whether in that case her statement was considered as dying declaration?
No.
No.
There is
because
no case of dying declaration. But
the case of
example is there.
It is a case of euthanasia. It is a case of euthanasia, madam, not dying
Okay. Because yes, that's what I was telling. Because in my knowledge, I don't know any case in which the statement of a person who is in coma has been considered as dying declaration.
The declarant must be dead. Unless the declarant death occurred, it cannot be considered as considered as dying declaration.
Yes, very true, sir, very true. Because that is the first thing that is the first thing, that the person who made the statement should be dead. If he is not dead, then his statement can be considered for corroboration or contradiction, but not as dying declaration.
But madam, there is a provision. If you go through section 32, a statement written or verbal of real facts made by a person who is dead, who cannot be found, who has become incapable of giving evidence, or whose attendance cannot be proved without an amount of delay.
Sir, this is the general. Yes, this is general statement regarding other aspects of section 32 is having other clauses also. Madam, but when we are referring to section 32(1), section 32(1) is referring to dying declaration only. Section 32 is referring to all four category of persons who cannot be found, who is not capable to make the statement. So, but that aspect is covering to 32(2), 3, 4 and other aspects, other provisions of section 32. But when specifically we are referring to 32(1), that is dying declaration. Dying declaration is a statement of a person who is dead. And if a person survives, then the statement cannot be considered as a dying declaration under 32(1).
But it is applicable. Clause 1 is applicable. The first part of section 32 is applicable to all. It has never said that it is applicable only clause 1.
Yes, it has never said, sir. But when we are referring to dying declaration, if you read section 32(1) and as per judicial pronouncements, this is my understanding. I may be wrong also, but this is my
madam.
understanding, sir, that dying declaration it becomes dying declaration only when the person dies. This is my understanding.
Unless the deceased dies, it can't be considered as dying declaration.
Yes, sir.
Yes, even as per section 104, even as per second part of section 130, that he must be dead before giving the evidence of dying declaration. But though these clauses are there, therefore I am thinking this never say that this is applicable to only clause 1, but we have to interpret in this.
No.
Yes, this is my yes, sir. This is my interpretation.
No, bolte that is in a different status, not in the status of dying declaration. Don't think that what the 33 also speaks of the same thing. If a person who is dead, if his statement is recorded, it can be taken in the subsequent proceedings. Mean that it cannot be, aisa nahi hai wo. That is a different story in different heads. But this is different.
Yes, sir. Yes, sir.
There is one last question from the Sandeep Parve. Dying declaration is a statement made by the person. Dying declaration is a statement made by the person while he was dying and state the reasons of his death. Okay, Sandeep Parve.
Yes. It's a fact. Yes, dying declaration is a statement made by a person regarding the cause of his death at the time when he is dying. But under Indian law, there is no need for him to be under expectation of death at the time when he is making the statement, unlike English law. Under English law, that person, when he is making the statement, he must be under expectation of death. That is not there under Indian law, and it is not required that immediately after making the statement, he dies. He may die after 2 days, after 2 weeks, or even after 2 months. But there must be a nexus between his death and the cause which he has stated in his statement.
Madam, there is a question. Thank you, madam. There is a question from the advocate Rajni Bhavaskar.
Yes.
The person who is in coma could not brought before court and his attendance cannot be procured. Take the example of the Arna Sharma. Suppose she might have made the statement and she went in coma. Then we cannot call her for that. Then what is the position? Will it not be treated as a dying declaration?
Her statement may be relevant under other provisions of section 32, but as per my interpretation, it will not be relevant under section 32(1). It will not be relevant under section 32(1).
It is relevant under 33.
Yes, it will be relevant under section 33, but it will not be relevant under section 32(1).
Because yes, clause 1 says as to cause of his death. That is important because reasons for the
as to cause of his death. But that nurse is not dead right now.
Yes,
she is in coma. Okay.
Yes.
Yes.
And suppose she dies, but
if she dies, then the statement, if it is related to cause of her death, if the statement which she made before she went to coma, if it is related to cause of her death or the circumstances of transaction resulting into her death, it will be relevant as her dying declaration. But only after if she dies.
There is a question from the Pallui Kore. Can a child's dying declaration is relevant? There is not consider his age.
Generally, the court look for corroboration. When we talk about child statement, the dying declaration made by the child, normally the court look for corroboration. And again, I'll say the parameters are there. If the court feels satisfied, then the court can convict a person. But this is a normal practice which is being followed by the court, although no age restriction is there when we talk about section 32(1). But we have various judicial pronouncements where in case of child's dying declaration, the court has looked for corroboration. Because of their tender age, a child may not be in a position to understand each and everything or to understand the circumstances or the causes. So in that situation, the court generally look for corroboration.
Thank you. There is another question from Advocate Gauri. Such a statement as to cause of his or her death can be made to any person available.
Such a statement, again, sorry, sir?
Such a statement as to cause of his or her death can be made to anyone.
Yes, it can be made to anyone. Yes, it can be made to any person. As I mentioned, if you remember that there's no need to make dying declaration only before the judicial magistrate. It can be made before a friend, it can be made before a police officer, it can be made before a doctor, it can be made before any person. It has not been provided in the Evidence Act that it is to be made before a specific person, no. But yes, evidentiary value, when we talk about evidentiary value, the evidentiary value of a statement which is being made to a judicial magistrate who has recorded that dying declaration under section 164 of CRPC, that always stands on much higher footing in comparison to a statement made to any other person. That is the only difference.
There is another question from Shroff. What about the dying declaration made to a child?
If a dying declaration is being made to a child is a competent witness. Under section 119 of the Evidence Act, the child is a competent witness. So irrespective of its tender age, the statement, if a person has made dying declaration to a child, he can as a witness appear before the court and he can narrate that statement before the court. But again, it is for the court, because normally when we talk about child witness, again the court look for corroboration, because the mind of a child is like a clean slate. So sometimes it becomes very difficult to differentiate that whatever statement a child is making, it is his voluntarily made a statement or this statement he has been tutored for that. So for that, when we talk about child witness, the court always look for corroboration. And I think it is 118 if I maybe it's 118 or 119. 118.
Yes, 180.
118, yes. So child is a very much competent witness if he is able to give a rational answer according to 118. Every person is a competent witness, but if due to tender age or old age or due to any other reason he is not able to give a rational answer, then only he will not be considered as a competent witness. But otherwise, the child is a very competent witness.
Thank you. Madam, there is a question from the advocate Kripal Rani Bisekar. Madam, can you please explain about dying declaration relevant in civil cases also?
Yes, very much under Indian law, it is relevant in civil cases also. And this was the second difference which I pointed out, if you remember, between the English law and the Indian law. Under English law, the dying declaration is relevant only in criminal cases, in case of homicide only. But under Indian law, it is relevant in criminal as well as civil. In both cases, dying declaration is relevant under our Indian Evidence Act.
Thank you, madam. Thank you, madam, for the answer.
So thank you so much.
You have to over to Yukta. My principals are also teaching the law of evidence. He's the expert in law of evidence.
Okay, sir. Okay, it's my pleasure. It's my privilege to make a presentation in front of him. It's my proud privilege, sir.
We to learn from you. It's the age of learning. It's not I am fully known everything.
Sir, law is all about, it's a continuous process of learning, but actually it was my proud privilege to make a presentation before you.
No, it is not like that. We too learn something from you. This is the purpose of learning.
Actually, sir, this
you are from which center? You are from center 1 or center 2? I
am from center 1, sir. Initially, I was in campus law center, but right now I am in law center 1.
So Ahuja is our good friend. That's why I'm asking you. PK Ahuja.
Okay, Ahuja. Sir, Ahuja, sir, he was in law center 2. He was professor in charge of law center 2. Yes, okay.
He's our
very nice person. Very nice person.
Okay. Ahuja sir has also recommended your name last time regarding that moot court competition. Therefore, I had your number. Then I contacted you.
Okay. So very nice person.
Sir, Ahuja sir had twice. Sir, Ahuja sir had given the name of the madam 2 years ago regarding the moot court competition. Then I had their number. I sent regarding the query. Thank you, madam.
Sir, it's my evidence is it's my favorite subject, and it would be my pleasure to be a part of these kind of events even in future also.
So, madam, I am teaching this subject for last 33 years.
Sir, that's why I said that it's my proud privilege to make a presentation before you.
You limited your subject. No, you limited your topic, but I covered everything in one lecture. It is available in YouTube if possible.
Okay, sir. Okay. It was overview. I think overview of this entire
an analysis of an analysis of dying declaration,
Yes. Yes.
an analysis of admissibility of.
Okay, sir. Okay, I'll definitely just go through that.
Thank you. Sir.
Thank you, ma'am.
Thank you, madam. Over to you.
Thank you, ma'am, for answering all the questions. Sir, am I audible?
Yes, you are very much audible.
Ma'am, with
To
your
you,
permission,
Yes. Yes.
ma'am, with your permission, may I proceed with the vote of thanks?
Yeah, sure.
Yes. Yes. Please go.
I would like to thank our resource person for today, Dr. Anju Sinha, ma'am, for sharing her knowledge with us and helping us gain clarity on a very important topic. I would also like to thank ma'am for her beautiful explanation and most importantly, her time from her busy schedule. Thank you, ma'am. You really have honored us with your presence today. I would also like to thank respected principal sir for making this lecture series possible. Furthermore, I would like to thank all the attendees for attending this session and making this entire program a two-way conversation. Also, I would like to thank our coordinator who organized this entire series and also gave me a chance to anchor today's section. Before I conclude today's session, there's a small announcement for our attendees. Tomorrow, there's a session on relevancy and admissibility of evidence by Dr. Aruna Sri Lakshmi ma'am. I would request all the attendees to join this session around the same time. With this, I formally conclude today's session. Thank you everyone and have a wonderful day.
Thank you, Yukta.
Thank you.
Thank you.